Well, good morning to everyone. It's an honor and a privilege to have Professor Suzanne Eckes from Wisconsin-Madison, a longtime friend, a very close friend. I have the joy to meet in my education law adventures.
In 2014.
In 2014.
Yep, so almost 10 years.
Almost 10 years. Yeah. And many of you already know Suzanne, and I'm glad she could do it again, came here again. And Suzanne is education leadership and policy studies professor at the Wisconsin-Madison University, and she will talk about LGBTQ+ discrimination and access issues. This is a very informal class. Suzanne, please do whatever you want for the time you consider is convenient and enough. Okay. And after that, we can open for questions and answers. Okay. And I think you have the floor. Okay. And please feel free to present as you like. Okay.
Great. Thank you. Hi, everyone. Bon dia. Yeah. Good to see all of you and to meet some new people this year. It's really wonderful to be back at the University of Sao Paulo and to be part of Professor Nina's class. So great to see all of you early in the morning. So as Professor Nina said, I'm going to be speaking today a bit about LGBTQ+ discrimination and access issues, but I want it to be an interactive talk today. So anytime you feel free, if you have a question, to interrupt me really at any moment. We can talk about this. I'd love to hear about where Brazil is, University of Sao Paulo is with regard to this particular topic. It's, I would say, an evolving topic in the US. So I spent my first 18 years on the faculty at Indiana University, where we had a partnership with the University of Sao Paulo. We've had some of your students come as visiting students, visiting scholars. And now I'm on the University of Wisconsin-Madison faculty, but and I've only been there about a year and a half, but when I first started at Indiana University, I had a few years of courses, and I received my very first call. I'd get calls all the time from former students because I teach really at IU, Indiana University. I taught very large classes of 150 students. And they would go out and become teachers and eventually become principals. And they would call me and say, "Hello, professor, this legal issue came up in my classroom. A student posted something about me on Facebook that wasn't very nice. What can I do?" And about 5 years into teaching at Indiana University, I got my first phone call from a former student of mine who was a teacher 2 hours away. And the teacher said to me, "What should we do? We have a student who's identifying as transgender and would like to use a restroom that aligns with his gender identity, would like to use the male restroom. What do we do? What does the law say? Can you give my school some guidance?" And my response, and this was, I don't know, about 15 years ago. And my response was, I have no idea. I didn't know what the law was. I hadn't heard of any case law from a legal standpoint. And I said, "Let me call you back." And so I went online, and there were very little guidance from the court, but there had been guidance from different advocacy groups on what to do, from GLSEN and different groups that advocate for LGBTQ plus rights for students and employees. And so I shared that guidance, and the school rejected it and said, "No, we're not going to allow this student who now identifies as male to use the that restroom. We're going to allow the student just to use the nurse's restroom, the one restroom in this very large high school. And I became really interested in that issue at that time because there were some articles on it, but just not a lot. And I thought, oh, this is really interesting. And each year I would get more calls about this particular issue. And eventually I had students who were identifying as transgender, of course, gay and lesbian students as well, who had experienced marginalization and discrimination as well, but more so the transgender students. So I'm giving you today kind of an update of where we have been in the last 15 years with regard to LGBTQ rights, with more of a focus on the T, on the transgender rights. And I'll talk about public schools, but I know some of you are interested in voucher programs and charter schools or school choice, private schools. So I'll talk a little bit about that area as well. But if you want to talk about a different area or any related areas, just feel free to talk and to chime in at any time. So just as a quick overview, you might be wondering, at 9:45 in the morning, what federal laws and constitutional provisions in the United States might provide protections for discrimination related to gender and or sex. So, and you might wonder, what is some of the new litigation? What does the case law have to say in this area as it relates to students and teachers? As the U.S. Supreme Court talked about this, have other federal courts, what is the legal landscape around this area? Well, it's evolving. So we have a federal law known as Title IX. I've spoken about Title IX, not within this context, but I've spoken about Title IX in the past at USP. It's a federal law passed by our Congress in 1972. And then there's also the Equal Protection Rights, Equal Protection Clause out of the 14th Amendment. So that's a constitutional right. So students sometimes rely on Title IX and equal protection when they claim, oh, I've been discriminated against based on my gender identity or sexual orientation. So first we're going to talk about K-12 students, and then I'll move into the legal context of employees. Title VII is our federal law that provides protections for public employees and private employees, but I'll talk about how there are exceptions in a private, especially private religious school context for teachers and educators, administrators with regard to LGBTQ plus status. So just very quickly in a nutshell, Title IX says that we can't discriminate on the basis of sex. So if you've ever spent any time in the US and you've heard of Title IX, has anyone heard of Title IX before? Do you know this federal law at all? It's often discussed in the context of athletics, that we have to give equal opportunities to both males and females in athletics. That's where you hear it discussed a lot, but it applies to scholarships in academics, and it certainly applies to this issue as well. At least I would argue it does. Where a lot of the debate is, what does on the basis of sex mean? So under Title IX, Congress passes in 1972, you cannot discriminate. Education institutions that receive federal funds cannot discriminate on the basis of sex. What is on the basis of sex? Does that include sexual orientation? Or is it looking at it more in binary terms? Does it include gender identity? What does that mean? It wasn't defined when the law was written in 1972. Anybody have any ideas? If you saw this, just you read this, and it says, we don't discriminate on the basis of sex. There are no wrong answers. Anybody want to try to make an argument that it should include or shouldn't? Yes. Right. So it's open to interpretation? Maybe. Yeah. Oh, yeah. When it was written. Right. 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 And especially 15 years ago when I got that first call, people didn't know how this would extend, what this means. Great. Anyone else? Right. Right. And we have different courts that maybe interpret Title IX differently, where they think on the basis of sex may mean this. And then, even though we have these wonderful laws that prevent discrimination, sometimes presidential administrations might interpret this differently. And school districts may or may not follow what those interpretations say. So you oftentimes can have a hodgepodge of different policies based on what this actual Title IX law really means. So I'm going to walk through some cases. I don't know if Professor Nina had the opportunity. I've written a couple recent papers on this, and so I'm going to refer to those papers a little bit to show you kind of where the courts have gone with this particular topic. With regard to Title IX, the Biden administration, Joe Biden is our president, so during the Biden administration, just this last summer, they can put out Dear Colleague letters, they can amend regulations. So in June 2022, they put out a 700-page document about Title IX. And within this document, which was open for public comment, really stresses that Title IX does provide protection to students who are gay or lesbian, transgender. What disappointed some people about this new rule that's being proposed out of the Biden administration is it didn't speak specifically to transgender students who are participating in athletics. But just a few weeks ago, there's been some helpful guidance on that issue, but not to the extent that maybe some observers were hoping. So the Biden administration interprets Title IX as discrimination on the basis of sex does include sexual orientation, and it does mean we cannot discriminate based on gender identity. The Barack Obama administration, when he was president, his U.S. Department of Education also interpreted Title IX the exact same way, or in a very similar way. When President Trump was in office, he rescinded the guidance that came out of the U.S. Department of Education and he rescinded it, didn't really put forth new language, but had rescinded it, which sent a message that maybe Title IX did not provide protections in that particular way, as we saw under the Obama administration and as now we see under the Biden administration. So we have that federal law, Title IX, and then we have guidance from the U.S. Department of Education around that federal law. But we also have constitutional protections that would provide protections for LGBTQ plus students. And it's called the 14th Amendment. And there's something called the Equal Protection Clause. And you'll see the very last sentence, it says, that's the part we're concerned with, nor deny to any person within its jurisdiction the equal protection of the laws. So today we're concerned about the 14th Amendment because a student, let's say, who is gay or lesbian, says, school district, Sunnyside School District is treating me very differently than it's treating students who are not gay or lesbian. So if those students are bullied for some reason, the school district steps in, they're harassed in some way. But the bullying and harassment that I experienced in school as a gay or lesbian student, she's not doing anything to address it. So we've had some lawsuits where the students argue under the Equal Protection Clause that I'm not being treated the same way as a non-gay student. And sometimes they've prevailed in those cases. They also can argue under Title IX, this is discrimination on the basis of sex. We also see it in the context of transgender students. And I keep using the restroom because it's just an easy example to think about, but I'll use other examples as well. Where a student would say, this is discrimination on the basis of sex when you don't allow me to use the restroom that aligns with my gender identity. I worked with a student in Louisville, Kentucky when I used to live in Indiana. And the student had identified, was assigned the sex at birth. The student was male, was Michael. And then at a very, very early age, the parents and the student started to realize, this student seems to be identifying more as female, and eventually went through a transition process. And by the time the student was in 9th grade, all the student's friends called the student Michelle, not Michelle, like instead of Sao Paulo, which is typically a girl's name, Michelle, refer to the student as Michelle. Michelle was using the female restroom. There was no problem whatsoever. And the only problems that arose were some community groups found out about it, some religious groups, and came in and started protesting. And this principal of this high school, Tom Aberly, he was on MSNBC, CNN, quoted in the New York Times, the Washington Post, said, no, we're here to serve students. We want all students to feel safe. And there have been no problems when the student first started using the female restroom. There were 2 students, and this was in April, and the school year went until June. There were 2 students who said, I don't feel comfortable using the restroom with this student, 2 female students. And so the principal said, well, then you can use the gender neutral restrooms, or you can use the nurses' restrooms. And by the next academic school year, they were all using the restroom together. It was a non-issue. And this is in Louisville, Kentucky. I don't know how familiar you are with the state of Kentucky, but it's not a liberal mecca. It's not Los Angeles. It's not New York City, who had been doing this kind of policy for 10 years. And there was no issue with it. But unfortunately, there are school districts across the country that have had issues with it. And then these students have had to rely on Title IX. This is discrimination on the basis of sex. And the 14th Amendment Equal Protection Clause. I'm not being treated the same as other similarly situated students. So those are the 2 big laws. There are also some states that have passed laws that prohibit this discrimination against LGBTQ students, prohibits discrimination based on sexual orientation and gender identity. But for those of you who are familiar with US politics, you might imagine like the state of Florida, Arkansas, Alabama, Texas don't have these types of state policies in place in the same way that maybe Minnesota or Massachusetts. So the reason I bring this up is there's a hodgepodge of state laws that provide protection. It's not all 50 states. It's about 24, 25 states. So the other thing I just wanted to point out, if you were taking constitutional law in the US, it'd be a 4-credit class, and it would be, you'd really get into the nuts and bolts of constitutional law. But I just want to point out within a few minutes, just to show you how the Equal Protection Clause under the 14th Amendment works a little bit. So the court has created these different levels of analysis. So if a case comes before the US Supreme Court and it involves, let's say, a gay student who says, I've been discriminated against in the way I've been treated at the school. What happens is the court will analyze the case under this idea of intermediate scrutiny, where it will say you have to have a really important reason to treat people differently based on their sexual orientation. But if a student had come to the school and said, I'm being discriminated against based on my race, I'm being treated differently, let's say, than the white students at the school, that would fall under strict scrutiny, the very top. And you need to have a compelling governmental reason to treat people differently. This is, I'm giving a very quick and dirty overview of, it's much more complicated than this. If, let's say, a teacher would say, I'm being discriminated against based on my age. Age falls at the bottom. That's rational basis. And so you only need, it's a much lower standard. You need a rational reason to create a policy that treats people differently based on age. You need a very important policy to treat people differently based on sex. So it's sex, sexual orientation, gender identity, usually. And you need strict scrutiny. It falls under strict scrutiny if you have policies at your school that treat people differently based on their race. So I just wanted to point that out. So here's some examples, and this came directly from this study in the article, I think, where I have that table A and that table B. So what was really interesting, over the past 10 years, at least 10 years now, courts have been asked to examine this issue, the restroom issue. And the plaintiffs in those cases have been transgender students. And the students have argued this is a violation of Title IX and or the Equal Protection Clause when I'm not allowed to use the restroom that aligns with my gender identity. Okay. And it went to court. Oftentimes it didn't reach a full trial on the merits. There were pretrial motions. A lot of them were preliminary injunction. But in all of the lawsuits, and from table A that there are over 10 lawsuits, I think we're up to 14 or 15. Some of them are under state law. In every single one of those cases prior to this year, it ended in a favorable result for the transgender student when the transgender student was the plaintiff in the case. So I kind of start to say to my class, oh, we're starting to maybe see a trend. Not every state, not every circuit had decided this issue, but we had a few federal circuit courts that at least ended in a favorable result. Maybe didn't go to full trial on the merits, but they won their preliminary injunction and then it would settle out or whatnot. So from that reading that all of the students, it ended in a favorable result for the students. And likewise, I had in table B that we have some cases where a cisgender student who is not transgender, initiated a lawsuit to say, I don't want to share a restroom with a transgender student. It violates my right to privacy. I have a right to privacy, and I don't want to share a restroom that aligns or that is with a transgender student. So there are about 5 federal cases that I have in table B. It's 4 or 5. I can't remember. I have paper in front of me, but in all of those cases, it did not end in a favorable result for the cisgender student. So, some would argue then that's a victory for transgender rights as well. So that was the case in the US while I'm teaching education law. I'll say, oh, look, we're starting to see more and more cases from the original phone call I had 15 years ago where I said, I have no idea what to tell you to do. Now I'll say, oh, you're in the 7th Circuit, which is Indiana, Illinois, and Wisconsin. Our circuit has a case, and our case would tell us that we need to pay greater attention to rights around gender identity, especially when it comes, we have a restroom case in the 7th Circuit. Oh, but you're calling me and you're from this particular state that doesn't have litigation. We don't have a lot of guidance, but your state has an anti-discrimination law or it doesn't. So it's this hodgepodge of laws still, but we were starting to see some favorable movement towards transgender rights in these cases. And I use the word transgender very broadly. We have gender nonconforming students. I look to GLSEN and different advocacy groups for the way that they define students who may be gender nonconforming and whatnot. And the reason I'm using transgender students is, and you'll see in all those cases in those tables that I provided, that's the language that the court used in those particular cases. But recently we had a very new development. So just a few months ago, in December 2022, we had a case go to the 11th Circuit Court of Appeals. And this was a transgender student who also argued under Title IX and the 14th Amendment, just like other students have in the past. Sometimes they argue both, sometimes one or the other. Sometimes the court will only examine one of the issues. But this case, Title IX, and equal protection, it goes in front of the 11th Circuit, and the court held in the opposite direction. So I'll give you just a little bit more guidance on that particular case. So this case, I should point out, only applies to those states that are in the 11th Circuit Court of Appeals, not the whole country, but now it makes, it's different. It's an outlier. It's a different case than all those other cases in Table A. The school board's bathroom policy is clearly they focused on the privacy rights of the cisgender students. So they talked about how lots of other students have this right to privacy. They shouldn't have to share a restroom with a transgender student. There was quite interesting couple of dissenting opinions of justices who disagreed with the majority. And one of the justices wrote, this decision is stigmatizing and it's humiliating. Another dissenting justice noted how all the other federal courts, circuit courts, state courts have gone in the other direction. And that what do you do with students who are considered intersex, who don't fit under either one of those categories? So now we have this different decision from the 11th Circuit. Does anybody know why that is kind of a big deal? For one, it's those few states under the 11th Circuit those students don't have rights, but there's maybe a bigger issue. The bigger issue is that now we have a split in our Federal Circuit Court of Appeals. And sometimes that invites Supreme Court review. And with the current makeup of our Supreme Court, it's very different than it was 5 to 10 years ago. There's a very clear 6-3 split, very conservative. Some would argue that leans quite religious, and then 3 liberal justices, or if you want to define it that way. So people are a little nervous now that there's a split. We've had over 10 years where the decisions ended in favorable results for transgender students. And now we have an outlier, which may invite Supreme Court review. So if this does go to the US Supreme Court, or a case like it, if another circuit follows in this direction, it goes to the US Supreme Court. We don't know what's going to happen. And I'm going to circle back to it because I'm going to discuss employment. What does this mean for teachers in a few minutes? Because there was a case that went to the Supreme Court where they did find rights for the teacher for discrimination based on sexual orientation and transgender or gender identity. So that may have implications for this issue, but let's get through students first. Any questions? Does anybody want to share with me, how is this different in Brazil, in a public school for, K-12 students ages 18 and under? Do they allow transgender students? Do they have rights in this country to use the restroom that aligns with their gender identity? Or is it like in the US where it's school district to school district? Oh, I see. Okay. It's not working. Yeah. Yeah. Very interesting. Thanks for sharing that. I would say it's quite different too around the US from school district to school district, certainly private to public too. Neat. Yes. Yeah. And that's what I think when I first got that phone call 15 years ago, that's what the school started to do. They started to allow the nurse's restroom. But the issue around that was there's one nurse's bathroom or one administrative bathroom in a very, very large high school, let's say, for example. So the student would have to walk, 10, 15 minutes across the high school to use this one bathroom. When the student, let's say, the student that I'd worked with in Kentucky, I'm using a different name to keep the privacy of the student. But anyway, the student for years had been seen as a female student, and there was no issue with the student using the restroom that aligned with the student's gender identity. The kids are the ones that usually don't have the problem with it. And oftentimes the teachers don't either, depending where you are. It's oftentimes the community members. And so we're seeing in some school districts, I remember even when I was living in Indiana, I was asked to be on this panel called the Noon Edition. It was a radio show. And they were going to, they asked me and the principal of this school and a few other people who do research in this area to talk about how successful it's been at this rural school in Indiana. And the principal said, stop. We don't want any attention at our school on this because it's not been a problem and we want to keep it under the rug. We just let transgender students use the restroom that they want to use and nobody cares. Like, we have bigger fish to fry. There are other problems to address, such as the achievement gap. We don't want to spend our time on this. And so once it goes on a live radio station in the state of Indiana, which is not liberal Mecca, no, we're going to start having protesters outside of our school. So let's shut it down. Don't talk about it. So sometimes schools will say you could use the nurse's restroom, or they just don't address it. Other school districts, I think it does really vary. So I mentioned that I recently moved from Indiana University, University of Wisconsin-Madison. In Madison, it is not an issue. I think I saw a survey from my son's high school that 35% of the students identify as LGBTQ plus in some way, which is very different from the high school when I was in Bloomington, Indiana, which is a college town and very progressive, but nobody questions. In fact, I don't know how many of you are Broadway fans. Anybody like Broadway musicals? Yeah. Do you know the Broadway musical? It just left Broadway right after the pandemic. It's called The Prom. Do you know that Broadway show? Okay. I love The Prom. I saw it on Broadway right before COVID, and it just left Broadway. And now high schools and school districts have the rights to pay for the license to do that play. Well, oh, yes. Yeah. And so it seems to me, it is something that you're starting to address here in a similar way. I mean, I think it's an evolving area and there's not a clear consensus of maybe where the population wants to go with these policies and with these laws. So it seems like we're in a somewhat of a similar place. We just maybe have a few more court cases to give us some guidance in some jurisdictions, and our U.S. Department of Ed has taken somewhat of a stand on it. But what I was just mentioning with this Broadway musical is that the theme is a school district in Indiana near where I used to live shut down the prom. Do you know what a prom is? The big dance at the end of the year. It's a very big deal. In Sullivan, Indiana, they shut down the prom because a girl was going to bring her girlfriend to the prom. And I remember, because I lived an hour from there, and I wrote a letter to the editor calling them a bunch of discriminatory, I said it in a very professional way. But anyway, this situation in Indiana became a Broadway musical. So it's left Broadway, and now high schools can produce it. The high school where I live in Madison was the first high school in the state to produce it. And I went to it the Friday night before I came here. No protests. The parents, everybody stood up and cheered when the girls kissed at the end. Not a big deal. But that play, that Broadway musical, could never happen. And in fact, they tried to produce it outside of New York City in New Jersey high school. And it was originally shut down because they were uncomfortable. They thought it was too controversial to have lesbian characters kissing at the very end of the Broadway production. So you can see from community to community, the issues around LGBTQ rights, I think, really fluctuates. And it sounds like that might be the case here as well. Okay. Okay, forbidden. So let me ask you this. So you had a fairly recent presidential election. I attended because I love Brazil. I kind of feel like this is, yeah, this is like my third home. Paris and Sao Paulo. Yes, yeah. And so I really like it here, and I read the New York Times and the Washington Post would cover Bolsonaro a lot. And I remember when I wrote the grant for Professor Nina and Monica to come, and some of the students, I framed it all around discrimination in Bolsonaro anyway, so perhaps under your new administration, like the US, things have changed with civil rights to some extent, at least in policy. Yeah. It just seems this is kind of the evolving issue. When I first started as a professor 20 years ago, a lot of my time was spent on a lot of calls around social media. And this student wrote this about this student, and this student wrote this about this teacher and this principal. And of course, special education law consumed a lot of our time with questions, or student disciplinary matters, which is still a big deal. But this is, I think, a legal issue that I get the most questions about, and I get asked to speak about the most when I go to do professional development programs for school districts, for principals at statewide conferences and whatnot. So I think it's an evolving area in a lot of different places. So I spend a little time on transgender rights around restrooms. Another evolving area is around athletics. And I think this one's even more controversial, and there's less case law on it. So if I would have got a call on this 5 to 7 years ago, I would have said, I don't know, because there wasn't a lot of legal guidance on it. And there's still not really that much. There's been a case in Idaho and West Virginia, Connecticut, a few places. And they're still evolving through the courts. So what about in Brazil? If you have, let's say, a 10-year-old who is a transgender male, okay, 10-year-old, and the 10-year-old would like to play on the male soccer team. It's part of, I know athletics isn't part of the school as much as maybe it is in the US, but like a community soccer team. Would, I guess maybe just the facial expressions I see from you are like, oh no, like it would maybe depend where you are, or maybe not. Would it be, no, you have to participate on the girls' team. You were assigned the sex of female at birth. Now you identify as male. You're going to play on the female team. Yeah, yeah. I mean, it sounds very similar kind of from community to community, right? Because we have the same thing. When I was in Bloomington, Indiana, which is, a college town, we had students, transgender male students who wanted to be on the lacrosse team with the male students. And they said, well, the state doesn't allow you to, but we don't care. Just play. It's like a non-issue for us until someone brings it up. And in Madison, it happens all the time and no one really cares. Especially at the younger level, at the elementary level. I think when you get into high school, around scholarships, more competitive, and the Olympians or college sports, it becomes more of a controversy. But this is also an evolving area. And I just wanted to point out, so you can see this is like dominates a lot of the conversation right now for people who study LGBTQ rights or care about this issue. Since 2021, over 30 state legislatures, so we have 50 states, 30 state legislatures propose anti-transgender athletic bills across the country, saying you cannot participate in athletics with the team that you want to, that aligns with your gender identity. And then 18 of those states have explicitly passed laws that prohibit this. Some of them have been challenged. And I have just one recent litigation. This case is very recent. So in West Virginia, there was an 11-year-old female student. She wanted to try out for the cross-country team at her junior high school. So at first, it seemed like she might be able to. The judge issued a preliminary injunction, which blocked the state law saying she couldn't play. So they were going to allow her to play or allow her to be on the cross-country team, on the running team, the track team. And then it went further, and her motion for summary judgment for both Title IX and the Equal Protection Clause was denied. So it's getting appealed again. So when people ask me, when I speak around the state or the country on LGBTQ rights and like, what is the litigation in this area? When I talk about athletics, I say, I don't know. It's very much evolving. And, there's been a recent wave of transphobic legislation in different states, in more conservative leaning states, that have tried to, like these retrenchment policies related to LGBTQ plus rights, especially as it applies to transgender students. So that's kind of where we are right now with athletics. It sounds like, from the great comments you're sharing with me, in Brazil, not so much of an issue yet. Your school, you just allow it, but not a lot of legal controversy around it. And this legal controversy really in the US is somewhat new as well. So I think many countries, many states, many areas are going to be addressing, this issue. So it's one area to watch. So here's another issue around LGBTQ plus rights. This is outside of Title IX and equal protection to some extent. This oftentimes relates to the 14th Amendment, a different part of the 14th Amendment that I'll talk about in a little bit. So in my town in Madison, Wisconsin, is going through a legal case on this very topic. And I don't know if you have anything similar in Brazil. So let's say you're a classroom teacher and you are teaching 10th grade. You have 15-year-olds. Okay, they're 15, and they say to you as their teacher, I don't want to, I've always been referred to as Michael. And I've always been, the pronouns that the teachers and my family use have historically been he and him. I'd like you, teacher of a 15-year-old, I want you to start calling me Michelle. And I want you to use the pronoun she, her, or they, no more he, him. I'm now identifying as male and I'm transitioning to Michael. Or did I say? Okay, the opposite. I'm going to be Michelle. I was Michael. Now I'm going to be Michelle. She, her, they. Do you have this happening yet? This is something somewhat newer that we're seeing litigation around, at least newer legally. Neutral language, gender neutral language, where the student asks the teacher in the school to use the neutral language. Are you having this yet? Yeah? Okay. So are we. And for most teachers, they don't care. Many don't. I'll talk about the teachers who do care in a little while when I get to employee rights. Most teachers don't care. Okay, I'll try to remember. I have a hard enough time remembering how to pronounce your name to begin with, but I am 100% supportive. I'm going to write it down, and I don't have a problem with that at all. Many teachers. But there is some litigation where teachers refuse for religious reasons. But what I have on this slide is when the parent gets angry, where the parent argues, hey, how come I didn't know that my 15-year-old is called Michelle in school and is referred to as she, her? I didn't know that. And I feel as a parent, my parental rights have been violated when the school doesn't inform me. I have a right to control my child's upbringing, also under the 14th Amendment, not Equal Protection Clause, it's Substantive Due Process Clause, another clause of the 14th Amendment. You're violating my constitutional rights. What do you think? It's a balancing of rights, maybe, of the student's right to privacy and the parent's right to control they would say, bring up their child in a certain way. They'd like to know this information. Yeah, that's and I think we're seeing that here too, where sometimes it is disclosed for if it's an open-minded parent, and if it's going to be an unsafe environment, it's not disclosed. So I'll get in. That's exactly where I was going with this. Mira. Right. You know, we have similar situations. Some school districts have policies. Sure, we'll use your preferred name or preferred pronoun, but it needs to be changed in the school database. And in order to change it in the school database, we need parental permission. Some school districts do take that approach. Yes. Yeah, well, this is all such a great discussion because this is what we are debating as well. We don't have a lot of legal guidance on this. There's a very recent case you'll see from 2022. This went to federal court, this exact issue. And the state of Maryland had a policy where they wanted to include parents as part of the team in the best interest of the child. Their end goal was to help parents to be a team with the school. If the student was transitioning or just maybe just changing pronouns, preferred names, maybe it's not something that you would need to talk about with a parent, but if it was something bigger and the student was interested in really facing a transition, that parents would try to be involved as much as possible. But the school or this, actually, this was a school district. The school district also said, we're going to balance the privacy rights. Sometimes it's not safe to tell the parents. Let's say it's like highly, I don't want to say all religious parents are, not going to be supportive, but let's say it's like a really evangelical family who has a real problem with, this issue. They wouldn't necessarily bring the parents in on, hey, we're using these preferred names or pronouns or this name in the classroom if it's not going to be safe, if the kid's going to get kicked out of the house, or it's not going to be safe. Yes. Yeah. I mean, this generation arguably, has a much different approach. Higher numbers are identifying, certainly. With this particular issue of like involving the parents, I was talking to the graduate class that I taught just last week. And some of my students, because they're dealing with, these exact issues. And the teacher said to me, I have a lot of teachers and principals in the class, what's the big deal? I work at an Orthodox Jewish school, a private school in Milwaukee. And all the parents want their kids to date and marry a Jewish kid. This is what a teacher told me, who I had in class. Well, I know some of the students in class are not dating other Jewish kids. I'm not going to go run and tell their parents. I overhear lots of things in the classroom. I don't run and tell their parents. Why do I need to go run and tell their parents that they're using she, her, and not he, him? That's not newsworthy. Like there are plenty of other things that I have to deal with that are way more important, like child abuse and like a kid can't read. So let's tamper down. And this is not that big of an issue. But at the same time, parents are taking issue with it. And that's how we led to this particular case in Maryland. The court rules in favor of the school district to say, you struck the right balance, school district, because you try to involve parents as the end goal, but you recognize sometimes it's unsafe to do so. Just as you said, it's not, you might have parents who are not going to be accepting, could kick you out. It's going to be unsafe in certain situations, especially when it's a bigger deal and the students may be trying to transition where it's further along than, today I'm going to be using the pronouns she, her, and maybe that changes in a year or two, but it's further along, it's a bigger deal. And the end goal is to involve parents. So we have a similar case in Madison, Wisconsin. It went to the federal district court. They kicked it out because they said the parental group that brought it didn't have standing. They didn't have a student who was, using different pronouns in the classroom. So we have these other cases, but again, it's very new. So I don't want to say that students in the schools are winning, but in the few cases that we do have, they are. But it's very, very early in these cases. They're all getting appealed. So we'll see where this really ends up too. But the parents are arguing, I have a 14th Amendment constitutional right to raise my child as I see fit. They're relying on earlier Supreme Court cases, which may or may not tell them that they have this right. And these unenumerated rights that come out of the 14th Amendment, you know, our abortion law was recently, our constitutional right to an abortion was recently overturned, the Roe v. Wade decision. You know, some have argued that, you know, the court had made a point that abortion, this idea of privacy is not mentioned in the US Constitution. Well, guess what? Parental rights is also not mentioned in the US Constitution. And so maybe you don't have as many rights. And the earlier Supreme Court cases you're relying on are much different. They're about the right to send your kid to a private school, the right, you know, religious rights of educating your child at home after 8th grade, if you're in an Amish community, don't really apply to this particular issue. But anyway, I wanted to bring this up because we are seeing some litigation. And here's just a case, very recent, a few months ago, 2022, a federal court in Maryland rules in favor of the school district with this policy of not running to tell the parents and balancing the rights. But what do you think about, I'll just mention this too, I'll let you read this over, this idea of providing a safe and supportive environment, going back to what Sarah said earlier about the best interest of the child. So that's kind of where the court came out with this one. I just want to mention we've had a few legal cases where the teachers refused to use the preferred names and pronouns in the classes. So in Indiana, where I taught, there was a choir teacher or band teacher, and he said, I'm not using your preferred name or your preferred pronoun. I'll call everyone by their last name. I'm just not going to do it. This is against my sincerely held religious beliefs. I'm not going to do it. I have a First Amendment right not to call you by what you want to be called. He lost because teachers have very few First Amendment rights in our K-12 system. You're hired to teach the curriculum. The court noted in that case, that's part of your job is to refer to students by their names and what they would like to be called. And this was changed by school policy in the school database, this preferred name and pronoun. So he lost, he had 14 claims that he had filed in court. So he lost his First Amendment claim. He lost his 14th Amendment claim. He lost his Title VII claim. And there was a teacher recently in Kansas who said the same thing, I'm not using those preferred names or pronouns. It's against my religious rights. They settled out with her and they paid her $75,000 or $90,000, something like that. It was a nice chunk of money. And I wrote an article recently, and I can't remember if I shared that one with Professor Nina or not. I can email it to you if I did. I wrote an article and I was like, why did you settle with her? Because I argue, you know, there's not a lot of law, and I don't know if I'm right, but she doesn't have a First Amendment right to say that in a classroom. And I don't think she has other rights that she argued. But anyway, I could be wrong. So anyway, we're now seeing teachers who are arguing this. We do have a college professor in the Sixth Circuit Court of Appeals who said, I'm not using your preferred name or pronoun. And that professor actually won his First Amendment case. But I would argue in that instance, First Amendment rights are very different in the K-12 setting than they are in higher education. You have many more First Amendment rights in a classroom at the higher education level. So I don't know how applicable that case will be to the K-12, but they're relying on it in some of these cases, certainly as informative. So anyway, that's where we are right now with regard to students, trans students, around Title IX Equal Protection Clause. I know I've been talking for an hour. I don't know if anyone needs a break. I do have more on employee rights of transgender rights that I can speak to, but I didn't know if we wanted to take a break or. Sure. Yeah, that sounds great. Good. Okay, well, welcome back. Hope everyone had a good coffee break. You're caffeinated, not too jittery. So I'm going to finish out this PowerPoint. We're going to kind of switch gears. I know I talked a little bit about teachers and employees, but I'm going to focus more on the legal aspects of the employment right issue as it relates to transgender employees or gender nonconforming employees, teachers, educators, administrators in schools. And then, so I just talked to Professor Nino, maybe I'll go until close to 12:30, and I'm going to move into a second PowerPoint that relates to this issue in the private school in the voucher context, to show some of the discriminatory practices that are happening in schools of choice, and a Supreme Court argument that may or may not have an impact on this area, that U.S. Supreme Court case from this last summer. So any questions about everything that we've discussed so far? I'm going to move on from this Maryland case about the balancing of the parents' rights, and the court ultimately held in favor of the school district and in the students. Yes. Right. Exactly. It just depends on what topic we're talking about. So there's been a lot of controversies around, is it the school's role to disclose that a student is pregnant? Is it this, and there has been some court cases on that topic. Is it okay to even, beyond the gender identity issue, to, when you're having parent-teacher conferences, to mention in passing that the student is gay? Is that something you talk to the parent about? Why is that necessary to disclose that? But certainly around health and safety issues, would have more of a chance of something where you'd have a school policy that you would disclose that to a parent. Like, let's say a student, the rise in mental health issues, especially after the pandemic. We've been paying a lot more attention to that. If a student is self-harming in any way, that might be something that a school social worker or counselor would probably set up a meeting with the parents, social workers, other advocates in that area to try to address mental health issues. Violence, certainly. Yep, absolutely. So I think more as you get closer to health and safety, that's why this issue around gender identity and just, outing a student who's not out with their parents, if they're gay or lesbian, is not necessarily something you should be or need to be discussing with a parent, I would argue. But as we get more along the continuum to, violence or harm, I think that's something that you would disclose to parents for sure. No. Christine, do you know, are there guidelines? Not that I know of. I think it's probably school to school, and oftentimes too, just more common sense, like this person, I used to be a high school teacher. So I remember sometimes in one particular instance, I had a high school student, and she was maybe 15 or 16 and was dating a 40-year-old. And we all knew about it. The teaching staff knew about it. And I remember a lot of discussion around, do we disclose that to her guardians? Because we felt that there was a health and safety issue with that. There was no policy that was in place or guidelines that we needed to do that. But I remember it was something we thought, that's maybe, has nothing really to do with me teaching. I taught French, but it, from what we're hearing from other students, maybe there was some sexual violence that was happening in that relationship that more people needed to be brought in. to that conversation.
Depends on if the parents are the suspects. So you talk with the authorities and you don't talk with parents, but usually they talk with parents about it. So.
Yeah, I mean, we certainly have, and it's governed by individual state law, child abuse and neglect statutes in each state. So anytime there's suspected abuse, especially when the abuse is happening in the home by a parent or a step parent, guardian, a grandparent, that's reported to Child Protective Services in an anonymous way. So we have, that's governed by state statute. And certainly anytime there's sexual violence, and you see more and more of this, this is really unfortunate. You know, I've been in this business now 20 years and I see more of these cases. I don't know if Christine agrees with me, but like sexual relationships between educators and students. Maybe we're just hearing about it more, but I bring that up because of, I talked about Title IX today. So Title IX can also serve as a legal avenue for parents who say, oh my goodness, this high school teacher is having a relationship, a sexual relationship with my 16-year-old. Title IX can serve as a legal avenue for that parent. So under Title IX, we have Supreme Court precedent to say that if a school has actual notice about sexual relationship or sexual harassment between a teacher and a student, you have to have actual notice. And then you have to, if you respond deliberately, if you're deliberately indifferent in your response, you don't do enough to try to intervene or stop it, your school district can be liable. And your school district can be liable for monetary damages. So when I was a teacher many years ago, we did have one teacher I can think of who married a former student. And I was teaching in a rural community along the Arkansas-Mississippi border. Nothing was done about it. But now I don't practice law anymore, but I serve as an expert witness once in a while. And those are the types of cases that I get called on the most, especially when I was in Indiana, where here's just one example. There was an attorney. He was a lawyer for many, many years, and he became a teacher, and he became a third grade teacher. And he did like a school yearbook. Usually you don't have a yearbook when you're in elementary school, but he did. And he would walk around the school with a camera around his neck all the time. And he would tutor one of the third graders over the lunch period. He would keep her in the school during recess at lunch to help her with things. And he would go into a room with a locked door with no window. Well, pictures surfaced with this teacher and a third grader on the internet. He's in prison right now. So first there was a criminal trial and he lost, of course, that case, and he's still in prison. And then the parents sued under Title IX to say, you knew about this and you responded with deliberate indifference. And when they talked to, during the discovery process, when they talked to the teacher's friends, teacher's colleagues, the teachers would break down crying. I would go to happy hour with this, I'd go to the bars with this teacher all the time. He was my very good friend. I had no idea that this type of activity was going on with a third grade student. So it was interesting because according to that Title IX standard, you have to have knowledge of the harassment between a teacher and a student, and there was no knowledge. And the school district settled, and this is public, it was either 1.6 or 1.9 million dollars they gave the family. That's a lot of money. And I think it was, even though I would argue there was no actual knowledge, but the school was not engaging in best practices. Why would you allow a teacher to go in a locked room with a student that people knew was happening with no windows? You know, that's just, when I was trained as a teacher, you don't work with a student alone in a room, in a locked room with no windows. Like, that's common sense. So anyway, they ended up settling. So I'm kind of getting off topic, but I wanted to bring that back too, because it's a Title IX issue. So I said how earlier, a lot of people think Title IX in the US, when you hear Title IX, a lot of people think it's just around athletics. Well, Title IX covers discrimination on the basis of sex, which relates to sexual harassment, including sexual violence or sexual harassment between teachers and students, and even students and students. So I don't know if that answers your question, but it's very case by case and kind of depends on what it is, what topic it is that we're talking about. Yeah.
So I don't know, because we have to protect the child, but they have privacy rights as well.
Right.
And I don't know how much privacy they have, because they can harm themselves.
Yeah.
It's not clear.
Yeah, and I don't know if it's clear in the US either. This is maybe getting into the weeds a little bit too much, but this Maryland case. So I have had people ask me, because they know I kind of been following some of these issues around privacy rights and disclosing to parents about gender identity. So one of my colleagues who studies LGBTQ rights from a social science perspective and does really interesting research around this, not from a legal perspective, she said to me, how does FERPA come into this? FERPA is a privacy law, Family Educational Rights and Privacy Act. And she asked me that this summer. I don't know if did I give you all an article that was published in the Marquette Law Journal about athletics? Did I give you that one? Anyway, I wrote it with her. I wrote the legal stuff and she wrote all the social science stuff. Well, anyway, she asked me that question when we were writing this paper this summer on transgender participation in athletics. And she said, doesn't a student have a right to privacy? What about FERPA? What about the Family Educational Rights and Privacy Act? And she asked me that, and I was like, I've never seen that come up in these types of cases. And there have only been a few of these cases dealing with preferred names and pronouns in classes. Or even in athletics. Let me do a search on our legal database, Westlaw or Lexis, and see if I can find anything. And I couldn't find anything really that spoke so much to the privacy issue, except the students who are cisgender who say, I don't want to share a bathroom with a trans student because that's my privacy issue. And the court hasn't found that they have a privacy interest there. But in this Maryland case, there are a couple paragraphs in the case about FERPA. So now Molly and I are writing a paper on this right now on FERPA, the Family Educational Rights and Privacy Act, because this Maryland case said, also the school district said, if we disclose this information to parents, could this be a FERPA violation? They brought it up. Is this violating the student's privacy right? Looking at the best interests of the students in privacy. But then that Kansas case I told you about where they settled with the teacher for like, I don't know, $75,000, I think recently. That case, before it settled, there was a motion for preliminary injunction. They also brought up the privacy issue under the FERPA law and went the other way and said, if we don't disclose this kind of information to parents, because the teacher said, I want to disclose this to parents, I feel like I'm a liar. And being a liar conflicts with my religious beliefs. So I want to disclose, and I should be able to disclose under FERPA, under the Family Educational Rights and Privacy Act, because parents have the right to know under FERPA, they have the rights to access educational records. So what's an educational record? That's kind of an interesting, so some school districts have these policies. You're going to choir teacher, in Indiana who refused to use the preferred names and pronouns. They had a policy, once the name's changed in the school database to the preferred name and the preferred pronoun, that's what you're using in class. But then once you change the name in the database, does that become an educational record? And then do you have to disclose it to the parent? So we don't have a ton of discussion within this context necessarily around their privacy rights, but it did come up in this Maryland case to some extent. It does come up in the trans athletic cases to some extent, and it's come up when the cisgender students argue, I don't want to share a restroom with the transgender student. I have a right to privacy under 14th Amendment. Yeah.
Inside of the classroom and everything. So with technology, we produce a lot of data and information, and what is educational record, what is not, like conversation between students.
Yeah.
Share or not. I don't know.
Yeah, I mean, I think this is a really interesting evolving area, great dissertation topic for someone because so like in Florida right now, a friend of mine just texted me the other day. I don't know if anyone follows the work of Preston Green. He texted me the other day. I couldn't believe this. Florida Governor DeSantis, who is very Trump-like and he likes Bolsonaro a lot. And so, and you know, that some of you may be supporters of Trump might say, I'm just telling you the facts. Anyway, he asked, he wanted to see the medical records of all transgender students in the Florida university system. I think if you were an athlete, I can't remember exactly how narrow it was. And so this friend of mine who I write with once in a while texted me and was like, isn't that a HIPAA violation of medical records? And isn't that a FERPA violation of just the privacy rights around the students? But I think his point was he was trying to get his head around how many trans athletes do we really have in the Florida higher education system? And I don't know it exactly, but it doesn't seem like that would be legal to be able to do something that because of the student's right to privacy. I don't know. So there's all kinds of, I'll use the word interesting things happening in certain states of our country with regard to transgender rights and privacy.
But here in Brazil, if it's related to the information, it's related to a violence or risk to the children, it's obliged to communicate because nowadays it's also a crime here. We have a recent law, it's called Lei Riborel. So if the schools know something about violence, it's obliged to communicate. Even school or hospital and health system, they need to, because it's a crime if they don't communicate that. So I think it's the boundaries that we need to think about violence. And also we can relate it to the privacy at medical, the ethical code. I don't know. Oh, yeah, but the information from Código de Ética Médica. So there's an article that says that if the information, there's privacy on that information, but if it's related to a risk, especially if it's children or adolescents, you need to communicate because there's no protection to that privacy. You need to communicate that. So I think it's a boundary that you need in all those conversations and everything. If there's something related to a risk or violence or a crime, I think it needs to be not always to the parents, but to authorities. I think it needs to communicate.
Yeah, and I think there are exceptions to like our FERPA, our privacy law. So after the Virginia Tech shooting, they did an amendment to our private FERPA to be able to share information with others around violence and students, if that student could be a violent threat to others. And then certainly at the state level, child protection laws in the K-12 system. And I don't know, Christine, can you think of, yeah. No, FERPA is not that recent. What was it, 94, 92? Yeah, but you know, what's interesting about FERPA, it has no teeth behind it. So let's say a school district does something, uses it the wrong way and discloses everything about a student, about their sexual orientation. There was no reason to do that. And it wasn't part of the educational record, or discloses their grades and, you know, whatever it is that shouldn't be disclosed. And and the school discloses it to a third party. If that happens and the parents are like, you can't do that, that's a violation of FERPA. FERPA protects educational records. Only the parents can see that in K-12. But you've given it to, you've disseminated this information. And now all these people know all this private information about my kid. And the parents want to sue under FERPA, they cannot. So there's no private right of action under FERPA. What happens is they can lose their federal funding, but I don't think anybody ever does. But they still worry about it. Like, it's still a law. I hear FERPA all the time working in higher education, because in higher education, FERPA applies to higher education. So if our registrar's office, if our administrative office turned over the transcripts and like medical records to a nosy roommate of a student, like, what? So, hey, did that student get an A in Suzanne's class? I want to, see if my roommate got an A, and I want to, access their records. And that information is turned over to another student. That's a violation of FERPA. But in the K-12 system, the parents have the right to see those documents. So it protects these documents, educational records. What's an educational record? It protects educational records from third parties. But then you can't sue. The nosy roommate gets the transcript and sees how the student did in my class, the roommate did in my class. The student whose transcript was disseminated, or medical records, whatever it was, they're not going to sue under FERPA. Now, maybe they could sue under a state privacy law. There are other legal avenues, but not under FERPA. Yeah, there you go. Yeah, COPA. Yeah, that's true. That's true. Surprisingly though, I don't see a lot of COPA litigation either, or a lot of FERPA litigation. There was the Gonzaga case, but that's older now. Yeah. Okay. So any questions? Great questions around privacy rights. Okay, so I'm just going to switch gears for a little bit and talk about more about transgender employees and their rights. And again, I hate to just keep it focused on transgender and not using other terminology about gender nonconforming. I'm using the language that the court has used in there was a big Supreme Court case from a few summers ago that kind of gives us some guidance in this area for public employees, actually private employees too. And it certainly applies to educators, and it applies differently in public schools than maybe it would in a private religious school. So I'll point that out as well. So like Title IX, Title VII also prohibits employers for discriminating in employment context based on sex and other areas, race, national origin, but we're focusing on the sex part of it. So it prohibits discrimination based on sex. And it applies to hiring, firing, compensation, sex-based harassment. And when Title IX was passed, actually, by Congress, they said, we're going to look to Title VII for guidance. It was kind of based off, at least some courts have recognized it's based off Title VII. Because Title VII came in 1964 and Title IX was passed in 1972. So I want to just talk about a U.S. Supreme Court case from 2022. And this was a pretty big deal because for years, we didn't know this idea of, prohibiting discrimination related to sex included sexual orientation or gender identity in employment. So in the 70s and 80s and even 90s to some extent, you still saw in some areas, teachers would be dismissed, or they would lose their coaching position, maybe not their teaching position, if they were gay or lesbian. Because there was they would sue under the Equal Protection Clause of the 14th Amendment. I'm not being treated the same as other people, and you don't have an important enough governmental reason to treat me differently. And oftentimes they would win their cases. So there was always the Equal Protection Clause, but that only applies to public schools because you have to have state action. The Constitution applies to public schools, not necessarily private schools in most cases. But then you had Title VII, which applied to private schools as well. But we didn't have any federal law, any comprehensive federal law that specifically said you can't discriminate in employment on the basis of sexual orientation and gender identity. And so transgender teachers were really at a loss, and also gay and lesbian teachers to some extent, because we didn't have any specific federal law. And the circuit that I'm in, the Seventh Circuit, a few years before this Bostock decision, ruled that yes, public employees are protected under Title VII based on sexual orientation. But it wasn't until very recently that the US Supreme Court ruled in a case involving an employee where the court in a 6-3 decision, so some of the conservatives, actually Justice Gorsuch, I don't know if you follow the Supreme Court a lot, ruled with the majority, he's quite conservative justice, ruled with the majority on this case to say, yes, Title VII, which prohibits discrimination related to sex, also covers sexual orientation and gender identity. So this was a big victory, really, for transgender, gay and lesbian. There's debate of whether it covers other areas like gender nonconforming employees, but this would extend and provide protections to teachers and to public defenders, district attorneys, even teachers in private schools to some extent. And I'll tell you where it wouldn't apply in a few slides. So it was interesting, this language: an employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. So it wasn't, and it said in this decision, we're not deciding the bathroom issue right now. We're not deciding athletics or the locker room issue, but we're just deciding clearly that Title VII prohibits discrimination and based on sex, also includes sexual orientation and gender identity. So after this decision, naturally, a lot of people in the legal community said, oh, well, now that the court found that Title VII says this, means this, we interpret it this way, then wouldn't Title IX also mean, if Title IX was modeled after Title VII, discrimination based on sex or on the basis of sex also includes sexual orientation and gender identity? I know I thought that, wow, this is a great victory. Although it had to just deal with employment, I think this is a victory for students as well, because we don't have a Title IX case at the Supreme Court level that says discrimination related to sex includes sexual orientation and gender identity. I thought, wow, this is great. Awesome. More rights for students. And the Fourth Circuit Court of Appeals agreed with me, and other federal courts agreed to say, in cases involving trans students, that we're going to look to Title VII. So here's what the Fourth Circuit said. Our Title VII guides our evaluation of claims under Title IX. Congress modeled Title IX after Title VII, and it passed Title IX with the explicit understanding that it would be interpreted as Title VII was. So we've had some Circuit Court of Appeals also say, wow, because of the Bostock decision, we think now there's more rights. It's clarified that Title IX should also provide protections based on sexual orientation and gender identity. We've never had a Supreme Court say that. We had the Obama administration give non-binding dear colleague guidance. The Trump administration rescinds that. The Biden administration is trying to make it more of a forceful rule, but we haven't had the Supreme Court say this. So this was kind of a big deal, I thought. But earlier I went through that case. This one, the Adams decision, where I said, oh, we've had, over 10 years of litigation where, like, the bathroom issues, they would all end in a favorable result for the trans student. But in this particular case, they used Bostock, the employment case, in a different way and said, no, Bostock doesn't apply. Bostock is an employment case, silly. It is not the same as a Title IX case, so we're not going to apply it. And what's interesting in this case from the 11th Circuit, this is the Restroom case, all the Republican appointed judges held against the transgender student, and all of the liberal appointed justices, the Obama appointed justices, went the other way. So That was kind of interesting to see. So anyway, it's now clear in the US that Title VII prohibits discrimination. Sex-based discrimination includes sexual orientation and gender identity. Do you have something similar in Brazil in employment? No. Well, we didn't either until recently. So, this is a constantly evolving area of law for sure, right? So I think this was an important case. When I was teaching in Indiana about 8 years ago, I would say, if you're a teacher or principal and you get fired for being gay or lesbian or transgender, doesn't really happen that much anymore, but you could just sue under the Equal Protection Clause in a public school. So one of my students came back to me and was like, I'm in this really conservative Indiana school district, and we, 2 school board members are leading this charge to get rid of an assistant principal who's a lesbian. And they don't want her at the school, and they're like pushing her out. Can I have her call you to talk about her, legal rights? So I used to teach the superintendent of that school. So I said, if you don't talk your board members down, like CNN and MSNBC and other news outlets are going to be at your school soon. Like, maybe I won't call them, maybe I will, but other people are going to find out about this, and you're going to, be a pariah. The news is going to find out about this. And we got her from the National Lesbian Law Center in California, free legal representation. And it went to court, and she eventually dropped it because she just got a principal position in another state, and she's just like, enough. But what was interesting during the litigation, I'm not making this up, when they were talking to the school board members about firing her for being a lesbian school leader, they said, we didn't care that she was a lesbian. We didn't fire her because she was a lesbian. We fired her because she was a woman. And we didn't want a woman leader. I mean, could you believe this? And so, either way, it's horrible and astounding. And at that time, this was 10 years ago, a while back. And at that time, it wasn't clear if discrimination based on sexual orientation, where it fell on this little triangle, if it was under rational basis or intermediate scrutiny. Whereas if you discriminated against this principal because she was a woman, it fell under intermediate scrutiny. So the lawyers who were there were like, shut up. Now you just made it so much worse for yourself. But there have been subsequent cases that kind of have elevated discrimination based on sexual orientation under intermediate scrutiny. But at the time, 10 or so years ago, it wasn't clear if it would fall under rational basis or intermediate scrutiny. So, it still certainly happened that LGBTQ plus educators were still certainly being discriminated against. Sometimes I just make these assumptions when I'm teaching, it doesn't happen so much anymore. I said when I was my first year teaching at IU, we were talking about the Pregnancy Discrimination Act and also how Title VII interacts with that. And I said, those cases are mainly from the 50s, 60s, 70s. There was a Supreme Court case, Little Fleur case. You don't really see that anymore. And I had a student raise her hand and say, we just forced out a teacher who was pregnant out of wedlock out of our public school because she wasn't a good role model. We forced her to resign, but the man who impregnated her was allowed to stay as a teacher at that school. So I don't want to make too many assumptions that, it's still in certain parts of the country and certain districts in the US, there's still discrimination, whether it's, under the umbrella of the basis of sex, whether it's pregnancy discrimination, because you're lesbian or gay, because you're a woman, because you have a different gender identity than what maybe the school leaders would like for you to, identify with. So that's where we are with employment. So there's a Supreme Court case that very specifically says discrimination related to sex also includes sexual orientation and gender identity. I'm just giving just a very big overview right now. So what about if you're working in a private religious school? Okay, so Indiana just gives me lots of cases. Even if I didn't live there, it just gives me a lot of cases because the state's a little bit different than some other states. So I remember one time I was on my treadmill and I was watching CNN while I was running. And I shouldn't be laughing. It's so Indiana. There was a Catholic school in Fort Wayne, Indiana. So it's very public. It's not, you can find this case. And the teacher was fired for using in vitro fertilization. The school said, we don't want you using in vitro fertilization. That's contrary to the teachings of the Catholic Church, and we're going to fire you. And she was all over the news and had this like high profile. Kathleen Delaney was her attorney, and had a lot of media coverage. Anyway, in the end, if I remember correctly, she was successful because I think her attorney argued, well, there are men at your school where they use in vitro fertilization with their wives, and they're not getting dismissed, but but this was several years ago, and I don't know if it would be decided the same way today. And that's because of something that's become more clarified around the ministerial exception. Okay, so I'll talk to you just a little bit about that. But before I move to that slide, I'll tell you another case in Indiana. There was a private religious school, a pretty progressive private religious school, where a school counselor was put on leave and eventually dismissed because she was gay. She had been married to her same-sex partner ever since marriage was legalized, and someone from outside the school district said, you can't do that. That's against Catholic doctrine. And so she was eventually dismissed. And that school had received $6.5 million in over 5 years in public taxpayer money because it received vouchers. And so that noon edition, I was on that radio talk show I told you about where they like shut it down because they didn't want it to go public with the student. Well, I was on that talk show with her attorney, and her attorney was all like, it all just depends if this counselor is considered a minister of the school. What's a minister? And we've had 2 Supreme Court cases that have given us guidance around what's a minister. And at the time when this was originally happening, it wasn't as clear from the Supreme Court if she would be considered a minister or not. So of course, the diocese was arguing, the Catholic diocese was arguing, anyone who plays any type of role in the school, a teacher, they are considered a minister for the purposes. We have complete control and can hire and fire who we choose. Her lawyer argued, no, she's not considered a minister because there's this idea of a ministerial exception. If you're considered a minister of the school, civil rights laws don't provide you protections. And so her lawyer was trying to argue, she's a school counselor. She is focused more on where a kid goes to college. Oh, you want to meet with me? You want to apply to Indiana University? You want to apply to Harvard? You want to apply to Michigan State? That's what I talk to you about. I don't counsel you in religion. I'm not involved in the teaching of religion at this private Catholic school. So I shouldn't be discriminated. I should have protections. And this teacher and another counselor eventually got fired. And then if you follow the news in this area, there were plenty of counselors and teachers and other employees, oftentimes at Catholic schools, but also Jewish day schools, Lutheran schools, that were getting fired for a whole host of reasons. So there was one teacher in California who was undergoing treatment for brain cancer, and she was let go. She was missing a lot of school, but had she been in a public school, the Americans with Disabilities Act would have applied to her to make some type of accommodations. There was another teacher who was undergoing in another state breast cancer treatment. And she was eventually let go at a private religious school. Same thing, she could have argued under the ADA, you need to make some type of accommodations for me. And so the reason I'm telling this is this idea, when you're in a private religious school, it's civil rights generally. So it's not just LGBTQ teachers who are losing their rights for being gay, lesbian, transgender. It's if you're undergoing treatment for brain cancer, disability rights, for breast cancer, if you feel like you've been discriminated against based on your age, there's something called this ministerial exception. And if you fall under it, the civil rights laws don't apply to you. And so there's this kind of discussion going on right now. Well, what about voucher schools? Maybe it's one thing. Maybe you draw a line between truly a private religious school that's not taking federal money. Still seems wrong. But these private religious schools that are receiving public taxpayer money shouldn't be permitted to discriminate in this way. And so that's a discussion that's happening right now. The court has said in 2 different times now, talked about this ministerial exception that private religious schools, if you fall under this ministerial exception, and I'll give you an example from the Fifth Circuit, in between the 2 U.S. Supreme Court cases where it wasn't so clearly defined, there was a piano player at a church. That was his job. He was the piano player, and they discriminated against him. And he said, well, I have federal civil rights protections. And they said, no, you don't. You fall under the ministerial exception because you play religious music. And I was like, no way. And the court ruled in favor of the religious entity and said, no, you fall under the ministerial exception. You choose the music, it's religious in nature, and sorry, these civil rights laws don't apply to you in the same way they would apply like in the public context outside of a religious entity. So that's where we are right now in terms of employment. I'm personally outraged by it, that especially I take particular issue that you can discriminate in this way when it's a voucher school. When like this school received $6.5 million in taxpayer money in the voucher program, but others disagree with me and they say the voucher money doesn't go from the state directly to the school. It goes to the parent, and the parent then chooses where they want to spend the money. So it's this indirect. I think that necessarily agree with that argument. But anyway, we haven't had a US Supreme Court case very clearly examine the discrimination aspect in whether it's related to students or educators so clearly in a voucher program. We have a voucher case, the Zalman case, that upheld voucher programs that you can use public money at religious schools. We have a big program in Milwaukee. Now I live in Wisconsin. Milwaukee's close to Madison. There's Indiana, where I was from, is the largest voucher program in the country. What's the largest voucher in the program? Florida has a big voucher program. And so this is kind of a really interesting area to watch evolve now. And with students as well. So there are plenty of newspaper articles. I just talked to a reporter the other day from Wisconsin who's looking at this. I talked to reporters from Florida who've published on this. Huffington Post has published on this. Lots of news outlets and some scholars have published on this. They're expelling gay students from voucher programs. So even though the school takes millions of dollars in taxpayer money, his voucher programs have been upheld, they're still being allowed to discriminate in this way. So I just want to see how much time, because I have another, just a really short PowerPoint. I could just go over like 10 or 15 minutes about, is that okay? Yeah. So Mirella, can you get my next PowerPoint up? Yeah, you can ask me a question while we're getting the PowerPoint up, of course.
Hello. I had a little question about the ministerial exception, because by its name and what you explained, I had a doubt about shouldn't it apply only to religious conflicts? Because when you talk about sexual orientation, it seems like there should be, or there could be, some religious conflict. But when you talk about the woman that was undergoing breast cancer treatment, it has nothing to do with religion. And why should the school be able to discriminate against her? Because it has nothing to do with religion.
That's a great point. I think it's just this idea of leave us alone. In so many words, we're a private religious entity, and you shouldn't be telling us who to hire and fire and how to run our enterprise. And that's a really interesting argument. I thought where you were going to go, this is what my students always ask me. They'll say, well, what religious rights are protected? So I cover this case in my class. My students almost fall over when they hear about this case. So now there's a lot of discrimination against LGBTQ students in private religious schools. That's like really well known. Not all of them do it, but fair number of them do expel gay students. And those schools are doing that because they're basing their arguments on, this is school choice, we should be able to do what we want. But also, this is our sincerely held religious belief. These are our religious beliefs. We should be able to do this. Well, it wasn't that long ago that, and there was a case that was decided in 1983. This is when my students can't ever get their head around. It's called Bob Jones University versus United States. You can Google it because no one believes me when I say it. Anyway, it was 1983, and it was a case that combined a university, Bob Jones University, but also a K-12 school, Goldsboro Christian. And in that case, they refused for many years in those schools to admit African-American students based on their sincerely held religious beliefs. So, and I bring that up to say, because the way the court held, it went all the way to the US Supreme Court in 1983. My students are like, do you have a typo on your PowerPoint? Do you mean 1963? And I said, no, it's 1983. But anyway, it went to the US Supreme Court, and it was a little bit of a different case because it was, we're going to pull your tax exempt status. You're not going to get the benefit of being a tax exempt school and get these benefits when you discriminate against African-American students this way. And Bob Jones University, when you go back and you read the original briefs and some of what the lawyers argued on behalf of the university, they believe that I'm not saying everybody believes this, because it was their religious beliefs at this school where they said, we believe the Bible forbids interracial marriage and interracial mixing. And so the government kept saying, we're going to deny tax exempt status. And then Bob Jones University would be like, okay, we'll admit African-American students, but they have to be married. And then they were going to pull their tax exempt status again. Okay, we'll admit single African-American students, but they can't interracially date. So then, all right, we're going to pull your tax exempt status again. And the Supreme Court held it's contrary to US public policy to discriminate against Black students in this way. So almost civil rights trumped the religious rights in that case. That was their sincerely held religious belief. When you especially read the pleadings from the Goldsboro Christian Academy, it's really something. So anyway, sorry, these were the sincerely held religious beliefs. So it begs the question now, would civil rights again trump the religious rights? So these private religious schools today are arguing it's our sincerely held religious belief not to discriminate against LGBTQ plus students. So that's just a question that I've raised with Julie Mead in my publications, and Preston and I have written a couple things. We're writing something right now. We're actually doing this presentation in Chicago in April, and we take a different twist on this Supreme Court case. So just in real quick summary, this Carson v. Macon case came down this last summer. It didn't, I don't think, got enough attention because everyone was talking about the overturning of Roe v. Wade and some of the other decisions that were very big that overturned a lot of precedent. Well, this did too. But here's the big picture with this case. The state of Maine is, parts of it are very rural and sparsely populated. And they had a voucher program, but the voucher program was just, they didn't run public schools in every little area of the state because it was so sparsely populated. They'd give vouchers and say, you can use these vouchers to attend like neighboring public schools or private schools. You can go to private religious schools, but we really want these vouchers to be used at schools that mimic the public school system. So you can go to like a Catholic school, but it can't be fire and brimstone, religion all day long. You have to also teach math and social studies, science, French. You have to do these other topics. And so anyway, they didn't give vouchers to some religious schools that were like really, really teaching a lot of religion all day long. And there were two schools in particular that brought suit. And these schools, so again, Maine just didn't want religious proselytization. They didn't want influence of religion so heavily involved in this program in Maine. So the state of Maine chose, we'll give you vouchers, but they can't be at like used at heavily religious schools. So these two schools, Bangor Christian Academy and Temple Academy, said, we want the vouchers to be used at these schools as well. So in June 2022, the US Supreme Court finds that once a state funds private schools, you also need to fund private religious schools. So this wasn't a case about discrimination of civil rights necessarily, although when you read the oral argument or you listen to the oral argument from the US Supreme Court, Justice Breyer kind of took them to task by saying, wait a second, these schools, Bangor Christian Academy and Temple Academy, teaches that the man is the boss of the family, don't they? He asked that question. Don't these schools teach that the man is the boss of the family? And don't they discriminate against Muslim students? Because it was in the record that there was some discrimination against Muslim students. And don't they, I don't know how he specifically stated it, but in the record, it was very clear that these schools discriminated against LGBTQ students. So there was like the man and the boss of the family, the religious discrimination, the discrimination based on sexual orientation and gender identity. Justice Breyer brought it up. And Justice Sotomayor, in her dissenting opinion, said, in so many words, I'm paraphrasing, whoa, it appears that you're, allowing one right to be, discrimination against some rights and then upholding the rights of others, more religious rights. So here's the outcome. This is a real game changer. So Justice Roberts, the Chief Justice, said in so many words, well, if you're a state and you don't want to fund religious education, then don't have a state voucher program. Okay, well, who's not going to have a state voucher program? Maybe the blue states. But, this just raises, even though the case wasn't specifically focused on discrimination, Preston and I are presenting this at ARA to say there's a lot to worry about with discrimination based on this case, because it almost seems, and other people have written on this as well, like Derek Black and Kevin Wellner has written on this and a few others, to say, is the court elevating religious rights over civil rights? We don't know. That remains to be seen, because this Carson v. Macon decision did not have really that much to do necessarily with discrimination. But it had, this idea of maybe religious rights will eventually be elevated over civil rights. We don't know. And the reason we argue this is we've seen other instances outside of education, like with adoption, there was a Supreme Court case dealing with adoption. Can you have to allow a Catholic agency to allow same-sex parents to adopt? In the Carson v. Macon decision, Justice Thomas, just one person, hinted at maybe birth control's next. Maybe gay marriage we're going after next, so like this idea of privacy rights, religious rights, where is that going with this particular court? And maybe some people will think when I present this in Chicago that we're a little too alarmist and we're overreacting a little bit. But Preston and I, in a paper we're writing right now for the Peabody Journal, argue that maybe race will be back on the table. So right now, LGBTQ rights are what is clearly being discriminated against in private religious schools. But in our paper, we say, and I'm just going to quote from our paper, Charlottesville, Virginia, and other documented white power movements in the US, including 2 white national groups that are seeking an independent state for whites, suggests that discrimination, is really alive and well in the US. So you haven't seen private religious schools argue that we don't want to admit African-American students or Latinx students or Jewish students. Well, I guess you've seen that a little bit. That you don't want to admit this group of students. And you just wouldn't imagine that that would happen in 2023. But as I'm writing this paper with Preston, we argue we wouldn't be that surprised if we, these white nationalists are trying to create Idaho as a white state. Well, if Idaho is a white state, Black kids aren't going to be allowed, or Latinx kids, or maybe Muslim students are not going to be allowed at these schools. So if we have a similar situation of like a Bob Jones University or a similar claim come before this Supreme Court, would religious rights trump the civil rights of these students? We don't know. We write, scholars have chronicled how progress made towards civil rights is often followed by a backlash. Specifically, civil rights experts have long documented that periods of advancement are followed by periods of retrenchment or efforts to chip away at previously achieved progress in the areas of civil rights. In other words, any expansion of civil rights for historically marginalized groups has often led to rise in intolerance. And go on to argue that this rise in intolerance may be not only shifting with public, but shifting with the court. Blake Clock, a professor of law, arguing in her 2022 law review, made these comments after examining the Supreme Court's expansive understanding of free exercise with the Carson v. Macon decision and earlier Supreme Court decisions that I didn't mention, the Trinity case and Espinosa. This new take on religious rights and free exercise rights in particular has caused concern that the court has now elevated religious rights over civil rights. Derek Black argues that Carson has added a touch of irony as the court has justified its shifting religious jurisprudence in the name of equity. So we're writing a paper on this. It's speculative. It's maybe we have a little touch of paranoia, but we don't think it's outside the realm of possibilities. We don't know if the Supreme Court in these recent religious cases, even before, I don't have 2 weeks to talk to you about the Trinity case and the Espinosa case, which preceded the Carson v. Macon decision, or the adoption case, or the cake bake case, the baker who doesn't want to sell a cake to a LGBTQ couple or a gay couple. Anyway, there's a lot of reason to sound the alarm bells, and that's what we're arguing in this presentation. So this Carson v. Macon decision, we think is maybe a game changer. We looked at how the court examined equity issues in the case And what we found was really it was Justice Breyer and then Justice Sotomayor who really paid attention to discrimination. But when you go look at the briefs, it shows like we refute the teaching of the Islamic religion with the truth of God's word. That's at these schools, you know, it's clear that they were discriminating in many different ways, but that's not what the case turned on. But we argue in future cases, how will the court rule when the discriminatory aspect? So I say maybe we're alarmist, and there is another author who we cite named Aaron Tang, who's also a law professor, and he argues, he thinks we're all overreacting. He says that if a state passed an anti-discrimination law that clearly just prohibits private religious schools from discriminating for participating in voucher programs, it just will help avoid this issue. I don't know, because the state of Maryland is involved in litigation. They have a state law, and Maine now has a state law to say public money not going to private voucher schools that discriminate against LGBTQ students, for example, or Muslim students, or the man as the head of the household, just gender in general. That states have passed these laws. Well, Maryland is involved in litigation on the topic right now, and we don't know how the case is gonna turn out. And if it goes all the way to the US Supreme Court, and the US Supreme Court elevates religious rights over civil rights, maybe Aaron Tang is wrong. I hope he's right, but maybe he's wrong. So that is it in a nutshell. And we have a few minutes for questions, if anybody has any questions. Okay, well, there you have it.
It was very interesting. It makes me think in a lot of things about religion and about gender. We have a decision in 2018 at the Brazilian Supreme Court about teaching religion in the schools. And this is a matter that concerns to the families.
Mm-hmm.
So the family in public schools, K-12, all over the country,
Yeah.
family chooses the religion that will be taught.
Yeah.
They hire the teachers.
Yeah.
And they use the public space for that.
Right. Yeah.
That's it.
Yep. And it's happening in the US as well, without a lot of clear legal guidance. And there's all sorts of other things going on, even with schools that are publicly funded for Jewish students in the New York City area.
Yeah. And it's not compulsory. So at that time, the student is not obliged to enroll, but it is offered on public schools.
Yeah. And you know, it's this idea of choice, like the parent is choosing, the family's choosing. And so there's this conservative commentator who criticizes me. Like Julie and Preston and I we get like trolled sometimes by certain people, like Sharon for America. I don't know if you can get emails from her too. Charlie Russo just got an email from her. Yeah, a lot of people get emails from Sharon from America who don't agree with what we write. And so there's this one commentator who writes publicly and criticizes some things. Right? It was, well, it's choice. In as much as I find this abhorrent that they're expelling LGBTQ kids or they won't allow kids in with same-sex parents, I find that abhorrent. But it's still choice, and it should be up to the parents. And, you know, you shouldn't dictate what these schools are doing because they're private. And so in our article for the Peabody Journal, we say, so Thomas, do you find it abhorrent if we now, you know, see a swing back to race? And it's abhorrent. But it should be their choice to not admit white or, excuse me, Black students or Latinx students, fill in the blank.
So when we speak about school choice in the US, it comprises all these things.
Yeah.
Not only the choice of the school, but the school inside the school activity choice as well.
Right. You know, and it's different laws govern these schools of choice different ways, because there's charter schools that are in most cases public schools, although that's even possibly going to go to the Supreme Court soon. Are they truly public? So we have charter schools, which are governed differently than voucher schools. There's homeschooling, which some people consider a form of choice.
Religion is a choice.
Or race. Right. Yeah. Right. Exactly. And we do argue that. And then people will say, that's not an immutable characteristic. You choose to be gay. They'll agree with us that race is immutable. But then I'll say, well, you chose your religion. Yeah.
Okay, Suzanne, thank you very much for your words and reflections about this issue, this new issue in education law. And thank you very much again.
Thank all of you for coming and your great commentary.
Okay, and we have it recorded on our YouTube channel. So if you want to watch it after, okay. So thank you.